Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you've ever had a question about your employment law rights, then you've come to the right place. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Each week, we dive into different employment-related topics that are on many Canadians' minds. I'd like to welcome my guest for today, Jon Pinkus, partner at Simfuru to Market. Before we get to today's questions and phone calls, Jon, tell us why it's important everyone understands their workplace rights, and perhaps you can share a case from this past week.
Right. Well, employment law is so important, not just because of how it affects us day to day, but the big one, of course, is terminations, right? Terminations are what we deal with the most often, and it's one of the most traumatic things that, the average person goes through. It's not only traumatic for the person who goes through it, but it's also traumatic for the people who go around, who are around them, their family members, and I've actually sometimes seen that firsthand. And we really see this happening right now in the tech industry, for example. People work there for many years, and the tech industry is now hemorrhaging jobs. Some of them in the news, some of them are on the way. And what I'm noticing is that people, particularly who are very short service or very long service, these are the people who are losing out the most in their severance packages, and especially at smaller companies. Larger companies too, but especially smaller companies. So a perfect example is when someone came to me recently who had been employed for 18 years. And after 18 years, the company said, look, we just don't have the money, the economy with inflation, everything, it's just not going well. People aren't investing in our company, and we have to let you go. We're going to pay you 6 months' pay. The minimum amount under employment standards, we're going to pay you 6 months' pay. And he said, well, I've been here 18 years. I think I'm owed more than that. And they said, well, the reason is we are a small company and we don't have a lot of money, so the law says we don't have to pay you more than that. Of course, that is not true at all. This is someone who was owed up to 18 months of his pay. And this is very important because employers will often come up with reasons why they don't need to pay you and expect you to take them at face value. Sometimes they say, well, we're a small company, so we don't have to do it. Sometimes they'll say it's because we don't have a lot of money, so we don't have to do it. And other times they'll say, well, because you signed such and such employment agreement, we don't have to do it. And in many of those cases, that's just not true, even in the latter case. So when you are receiving a severance package, very important, go to Pocket Employment Lawyer, speak with an employment lawyer. You have nothing to lose by at least finding out what you could be owed.
Okay, if you want to get in touch with Jon and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. Let's kick things off by taking our first call. Jon, these calls come to us from your radio show across Ontario and Canada. Take a listen to one of the live questions.
I work for a fairly large organization. I'm a senior management there. I've been there 23 years. I know there's a lot of hours that I put in because of my role, but recently I had one of my key reports resign over the last 3 months. So I'm pulling in anywhere from 70 to 76 hours per week. I've been asking for compensation, and I'm not getting any response, and I'm wondering where I stand, if anything, on that.
What do you think of that?
Right, well, this is a big change, right? If, he didn't say how many hours he was working before, but assuming that he's working a standard work week of, 40, maybe 45 hours, all of a sudden he's working 70 to 76 hours, and if he's being paid the same. In fact, even if his pay was increased, if he doesn't give them permission to do that, that is a massive change. And when you have a massive change that you have not agreed to, that's when we're talking about a constructive dismissal. And if your employment is constructively dismissed, either by changing your pay, changing your hours, changing your location, and it's significant enough that it is a constructive dismissal, you can leave and pursue your full severance pay. Now, very important, you want to make sure you speak to an employment lawyer before you do that, because you won't know if you're in that situation until you have spoken with one, and if you do that prematurely, you have resigned. But in this case, this is certainly a very good candidate for constructive dismissal. And I could tell you how much this person is owed, but if we look at the pocket employment lawyer and we look at how long this person has been there, 23 years, 59 years old, senior manager, we see this is someone who could be owed 24 months of their pay. And if he's earning $108,000 a year, $216,000 would be what's at stake here, right? So this is a key reason to speak with an employment lawyer. And if you're not prepared to do something like this, you may have to just get out and seek your severance so you can move on.
Okay, let's take a short break. And when we come back, employment lawyer Jon Pinkus from EmploymentLawyer.ca presents a primer on workplace rights for injured workers. Stick around. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Employment lawyer Jon Pinkus from EmploymentLawyer.ca is taking your employment law questions. If you want to get in touch with Jon and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, EmploymentLawyer.ca. We have more calls and questions coming up, Jon, but before we get to those, let's talk about today's main topic, a primer on employment rights for injured workers. We have 5 commonly asked questions. The first one, can an employee take a medical leave or use disability benefits through an insurance provider if they can't work?
Well, the answer to this is yes. Your medical insurance benefits are there for a reason. They are there for you to use. The insurance company may not like you using them. Your employer may not like you being away from work, but that is your right. It is a human right. And so if you are unable to work, the first place you go is not to your employer, and in fact, it's not to your lawyer, it's to your doctor, it's to your medical professional. And if your doctor says you should not be working, that's the time to take off work. That's the time to send that letter to your employer, the medical certificate that you can't work. And if it's going to be an extended period of time, you may want to think about applying for short-term disability and long-term disability, because if you are fortunate enough to have those plans, you should take advantage of them.
So first you have your doctor's letter, then you go to your employer and then insurance, or insurance and then your employer?
Well, usually insurance only comes into play if it's going to be more of an extended leave. Like, let's say instead of a few days, it could be weeks or months or even years. That's when you start thinking about short-term disability or long-term disability. So in the immediate short term, you just want to make sure that you're communicating with your employer so your employer doesn't start to think that you're just not coming into work, right? You have to communicate. And I've actually seen people with legitimate reasons for not being able to work, but they've gotten into trouble, and in some cases, some trouble that's hard for me to fix because they have not communicated with their employer or they haven't done it in writing. So when you're communicating with your employer, typically you want to do it by email or at least text message.
Okay. Does your employer then have the right to know what your diagnosis is? That's the second commonly asked question.
No, they don't have the right to know what your diagnosis is. In fact, a good medical form that your employer will send you will specifically state that they're not seeking your diagnosis. What they're seeking is your prognosis. How can they plan? How can they accommodate you? That is totally fair game, and your employer probably should be asking for that information so that they can accommodate you. But they are not entitled to know the details of your diagnosis because it's on a need-to-know basis, and that's just not something that's relevant to them making arrangements in the workplace.
Okay. Question number 3. Is your employer required to make accommodations for you at work, even if they make things a little bit difficult?
Right. Well, the standard here is not a little bit difficult. The standard here is actually called undue hardship, which means that an employer has to take measures to accommodate you, even if they are inconvenient, unless they are extremely difficult, almost impossible. In fact, in many cases, the way the tribunal describes this is it has to be something like it would threaten the viability of the business or it's just operationally impossible. And in most cases, there's going to be some way to accommodate you, right? And an excuse that is often used is, well, we just don't have the position anymore. which leads me as an employment lawyer always to ask is, really, do you not have the position anymore, or do you just like the person you replaced better, right? And if it's the latter, that's going to be a wrongful dismissal and a human rights violation.
Okay, question number 4. Can you be fired because of your illness or injury?
Absolutely not. You cannot be fired because of your illness or injury, and if you are, then that is going to be a wrongful dismissal and a human rights violation. The only exception to that is if you have been off for so long or your illness has become so severe that you are never going to be able to return to work. In that case, you will be entitled to actually less severance because your employment has become impossible, what we call frustrated. But in almost every other circumstance, if your employer is letting you go because of your illness, that's not only something that's going to entitle you to severance, but you could be entitled to some human rights damages on top of that. Big no-no for employers.
Okay, question number 5. How do you determine the correct compensation for someone if they are let go because of their medical condition?
Well, the same way that we look at compensation for everyone else. We look at your age, we look at your position, we look at your length of service, and you can put those into the pocket employment lawyer. But in that case, we may also want to be looking at your medical condition and the impact that that is going to have on your ability to search for work, because anything that poses an impediment, whether it's trying to replace a really niche job or having to look for work when you're disabled or when you're in the middle of a pregnancy, which is another thing we look at, then that is going to extend the severance entitlement. So another reason why, if you've been let go because of a disability, all the more important to speak to an employment lawyer.
Okay, let's listen to another phone call from one of your live radio shows. Take a listen.
Our company's doing some restructuring. They will be getting rid of people. Our salaries are based on an X amount every year plus bonus, and that bonus varies depending on how profitable the company was. So if you're making in the mid-80s, you ended up getting close to, like, let's say 100. When they do give you a separation, will they base it just on your salary, or does your bonus also have to be worked in, even though it's not exactly known what it'll be for that coming year?
What do you think of that?
The bonus. The bonus is often a huge question. In fact, in some cases, the bonus is worth more than the severance. In some cases, someone's receiving a commission, and their employment may be largely commission-based, but the employer calls it a bonus and decides, well, we're going to only pay you 20% of your full compensation because the rest is just discretionary. And that is generally not how it works. When we're looking at your compensation, we're looking at all components of your compensation, including your commissions, if you have a taxable vehicle allowance, if you have a bonus. And we're looking at the bonus that you would have earned up until the date that you were let go. And we look at the bonus that you would have earned if you had kept working. And generally speaking, if you're wondering whether something should be included as part of your severance package, you ask yourself, would I have received this? And would this have been something in my T4 if I had not been let go? And if the answer to that is yes, that's something we got to be looking at.
Wow, great information. Okay, after the break, Jon from EmploymentLawyer.ca will discuss pay raises and hear how the Ministry of Labor stacks up against an employment lawyer. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. Welcome back to Ask a Lawyer. Jon Pinkus from EmploymentLawyer.ca is taking questions about your workplace rights. If you want to get in touch with Jon and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or visit their website, employmentlawyer.ca. We still have lots more to discuss, and here's another call from your radio show.
I worked for a large non-union HVAC company 3 years, and I never got a raise. And I've been trying to sit down with my boss. Whenever I questioned him about it, he says, yeah, we'll talk about that tomorrow. So whenever the next day came around and I went to have this meeting, I was let go with the story of, while we're downsizing, I don't have any work, even though we're booked 3 weeks out with calls. Later that day, I saw my job posted for much less than what I was making. So I think I was let go just because he didn't want to pay me what I was owed.
John?
Well, there's a few misconceptions here, so let's go through them. Let's pull them apart. So the first thing is your employer does not have to give you a raise. In fact, this is something that a lot of people are probably thinking about right now with inflation. Well, my employer has to meet the rate of inflation, right? Otherwise, it's a pay cut. It would be an interesting argument, but the law doesn't recognize that, at least as it currently stands. So your employer does not have to give you a raise, even if you're asking for it. The other thing is, if your employer has let you go, they are actually allowed to lie about the reasons they're letting you go. If they may perceive that as, softening the blow of termination, they may have good intentions, bad intentions, it doesn't matter. They are allowed to let you go as long as they're not doing it for a reason that's prohibited by statute, right? Like human rights or safety reprisal or something like that. As long as it's not something like that, they are allowed to do it. And this is a case where they would be allowed to terminate. They just have to pay the proper severance. And what do we look at, of course? We look at your age, your position, and your length of service. And even if you've only been employed for a very short period of time, a couple of years, even in fact a few months, you still could be entitled to severance. So if we throw up the pocket employment lawyer and we look at someone who has been employed for 3 years as an HVAC technician, earning $60,000, 43 years old, this is someone who's going to be owed potentially 3 to 5 months of their pay. So that's what we can do about it here, right? Can't get you your job back, can't do anything about the fact that you've been replaced, but we can seek you compensation so you can have some time to get back on your feet.
Okay, and your firm has helped non-unionized workers through all kinds of problems. So let's take a look at an example based on some of those matters. Sarah was let go from her job after 9 years. Her boss told her she didn't qualify for severance. Sarah's brother suggests she calls the Ministry of Labor instead of a lawyer because it would take years for her claim to get to a judge.
Right. Well, what an important question. What an important issue to talk about. That is, with all due respect to Sarah's brother, some of the worst advice you can possibly receive. The Ministry of Labor is very good for a lot of things. They're very good for overtime. They're very good for vacation. They're very good for wage claims. They're very good for safe occupational health and safety issues in the workplace. But they are almost never the place that you want to go for severance. They are, in fact, usually the last place that you want to go for severance. If you go to the Ministry of Labor to seek your severance entitlements, first of all, in many cases, they're going to tell you there's nothing we can do for you because if your employer's complied with the Employment Standards Act, which isn't very much, that's all they're authorized to do. The other problem is if, let's say, you've been let go for just cause, or you're taking an action for constructive dismissal, and you go to the Ministry of Labor, and then you find out later, at the Ministry of Labor, I can only go for 8 weeks, and now I'm on the pocket employment lawyer, and I'm finding that actually I should be entitled to 12 months. Well, guess what? If you have gone too far in the process, you still want to give us a call because we may be able to withdraw it. But if you've gone too far in the process and too much time has passed, you might be stuck. You've now made your election and you cannot take a civil action, which means that your full entitlements are gone. So that's one of those mistakes that you cannot take back. So please, please, at least make the call to an employment lawyer before you take that step.
And why do you think people believe, like Sarah's brother, that it would take years before a judge would see the case?
Well, because in many cases that is exactly what happens, right? If we're talking about sometimes family litigation or state litigation, sometimes they can be very long depending on the nature of the dispute. Employment disputes generally aren't that complicated. The employer knows they have liability. They know the situation is not going to get better for them if they just let things fester and fester. In fact, it'll probably get worse. And for that reason, employers tend to be motivated, rightly so, to negotiate early, often before any legal action is started, and sometimes in a matter of weeks. It doesn't have to be long. It doesn't have to be acrimonious at all. Look at it as a business negotiation. Very straightforward.
Okay, thanks, John. Another quick break, and then more employment law insight with Jon Pinkus as we examine wrongful dismissals and the countdown clock under compensation. Stay with us.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. Jon Pinkus from EmploymentLawyer.ca is answering your employment law questions. You can connect with his team by calling 1-888-861-4555, email ask@EmploymentLawyer.ca, or visit their website, EmploymentLawyer.ca. We have time for just a few more questions. Here's an email that came in. How do I know when I've been wrongfully dismissed? Does it happen if I've been let go for the wrong reason? That's a good question.
Right. Well, this is a question we get all the time, and it's not about the reason why you've been let go. It's about how much severance you have been offered. So the way to find out is you go to pocketemploymentlawyer.ca, you go to the severance pay calculator. It's totally free. It's anonymous. You don't have to put your name. You don't have to put the company's name. You just put your age, your position, your length of service, and you will find out if the severance package you have been offered is adequate. And if it's not, it doesn't necessarily matter the reason your employer has let you go. They just owe you more compensation. Like we talked about earlier today, they can lie to you. An employer is allowed to lie to you, either for good reasons or bad reasons. But that is not the question. The question is whether they've given you adequate severance.
Okay, time for one last question that I'm sure your firm fields regularly. Here we go. I was offered 2 weeks of severance pay with an extra 5 weeks pay added, but for every day I don't accept the package, they take away a week's pay. After 5 days, the offer will disappear completely. Should I just accept it right now?
No, don't go into bully tactics. Don't succumb to bully tactics here. This is exactly the time to speak with an employment lawyer. Remember, your rights do not expire for 2 years. It's 2 years you have to file a claim for a civil claim. So give us a call. Go to pocketemploymentlawyer.ca. and we'll be able to deal with that, because that is just totally bully tactics. And chances are they're doing that because they owe you a lot more.
And you do see that regularly? You see a lot of this?
Not quite that aggressive, but we do see a lot of times where they're saying you have a week to sign and then the severance package is gone, or we're only going to pay you your minimum entitlements. And that is actually almost universal. That's very normal, because the employer is not offering this to you out of the goodness of their heart. They're offering it to you because they want resolution as much as you do. So speak with an employment lawyer so that you have your side of the story and that you have your side of the negotiation.
Good advice. Thanks, Jon. Thanks for being here today. You can catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show at EmploymentLawyer.ca, visit cp24.com/askalawyer. We'll be back next week when we take a look at the things your employer won't tell you. Thanks for watching.